السلام عليكم حضورنا الكريم.
May the peace of God be upon you all, distinguished guests. Our dear viewers, would like to welcome you to the third session of Al Jazeera Forum in its 15th edition. We'd like to welcome you all to this session, which is entitled International Justice in the Scale of the War on Gaza. So when we take into account the confrontations and also the diplomatic efforts and also the political pressures and initiatives in order to come to a kind of a political horizon for the Arabo-Israeli conflict, the Israeli war on Gaza has opened a new legal pathway. The most important phase of this legal pathway that was opened was the case that was opened in court by South Africa. So the legal repercussions and also the fact that South Africa sued Israel, this has not started with this war only. There have been other cases and other investigations that have been carried out in the different institutions of the judicial and judicial system. And we have this case by South Africa against Israel before the International Court of Justice on charge of genocide, because this is the mother of all charges. We're talking here about genocide and the legal prosecution and the legal courts that is looking into it, the tribunal. We're talking here about the ICJ. Perhaps there are so many questions that are being posed in this regard, particularly in this session. Can this new legal pathway put an end to impunity? Is it going to be able to bring about justice, and what is the added value that this legal pathway can bring about in order to find a solution to this Arabo-Israeli conflict? This is one of the questions in addition to many other questions that are going to be posed in this particular session, in addition, of course, to the questions that you're going to pose after the session. So we'd like to welcome the different panelists in this session. We have with us here Mr. Rani Abdu, who is going to be with us here in this session. We have also Mrs. Lamis Adik, who is a lawyer and a Palestinian activist. And also we have Catherine Powell, who is an associate professor in public law from Cape Town University. And also we're going to have via Zoom as well Richard Falk, the UN prosecutor for human rights in the Palestinian territories. It seems that he is ready and with us here live. So before we start, we'd like to screen a video about what has happened in the Shifa hospital in Gaza. Let's watch the video.
يوم حصار مجمع الشفاء الطبي أول يوم كان يوم الاثنين الساعة 2 بالليل. كنا مداومين في قسم العناية المركزة. صارت خبطة قوية، بعدها صار إطلاق نار من كل مكان وصوت دبابات، وعلى المكبرات صاروا يحكوا إنه أنتم حاصرين ومحدش يطلع من الباب. فجأة هيك في ثواني
أبويا كان في الاستقبال موجود، تمام. في الاستقبال بجانب العناية الحرجة. كان أبويا في النتفة هذه، في النتفة اللي هنا أولاً، كان هنا في النتفة هذه. 30% من اللي كانوا موجودين في المنطقة اللي هنا في الاستقبال كانوا عايشين على الأكسجين وعلى الأجهزة.
أنا من سكان محيط الشفا. بيت أهلي هذا له في محيط الشفا تقريبا 63 سنة. أنا هذا بيتي المدمر هذا واللي وراه، وهذا شارع الشفاء. بعد ب3 أيام، ثالث يوم من العملية تبعتهم العسكرية، لما دخلوا علينا فتحوا الباب، قال يلا اطلع الجيش بده اياك. طلعت قال لي اشلح اواعيك، قلت له بقدرش اشلح انا عيان. المهم صار يغوش علي، قال لي اشلح يا حيوان. شلحت الاواعي، قال طب امشي، قلت له بقدرش امشي، انا ما بقدر امشي.
نقلونا من على الساعة 1، جابونا على الشقة هذه. طبعا بعد هيك ثاني يوم الساعة 9 الصبح نزلونا من الدرج هذا، نزلنا على الدرج هذا، ضلينا نازلين واخذونا، طبعا كلنا مكبلين الايدين زي هيك، وضلينا نازلين معاهم. طبعا رفعوا عن وجهنا بعد ايش لما قلنا لهم مش شايفين، ونزلونا على الدرج، ضلينا نازلين وضلنا نطلع على الشفا هلقيت.
من بداية ما بلشوا بالتجريف، يعني من أول ما دخلوا بالتجريف، ودخلوا بالدمار. فجرفوا من هاي المنطقة، كان فيها شهداء، فكلها جرفوها هان هيك وقعدونا عليها، وانت قاعد جنبك هيك الشهداء، دمهم، ريحتهم. يعني كان الموقف كثير هيك حساس.
كان في زلمه هنا هو وبنته، وقف هيك قال لها احنا هنا 8 اشخاص 8 مرضى، يعني 16 نفر كانوا موجودين هنا بالضبط. قالت لا انتم اذا ما قدرتوش تعتبروا من قناه حماس. ما رضيت تطلع، تخاف على المطرح. هذا اول اعدام شفته.
كل المستشفى كانت نازله هيك قاعده كلها على الارض هان هيك، كلياتهم كانوا على الارض، وبحققوا معهم واحد ورا الثاني تصوير عن طريق الكاميرا، عن طريق الدبابه، واللي بدهم اياه يطلعوا، بدهم اياه ياخذوه. وكانت العياده الخارجيه هذه زي السجن عاملينها، يعني فوق ال 300 شخص او 400 شخص كانوا محجوزين فيها.
اول شيء جابوا لنا مواطنين، حطوا لنا من الطواقم الطبيه، حطوا لنا المربط على يدينا، تمام، على يدينا مربط وهيك تقريبا، وقعدونا على الركبه تبعتنا، على الركب زي هيك، زي هيك قعدونا في المظله. هذا كله كلام في المظله.
لما كانوا يجوا كانوا يخلوهم قدامنا انهم يعني يشلحوا ملابسهم، فاحنا لا ارادي يعني انا وزميلتي كنا نلف وجهنا عنهم.
وقال لي الجندي اشلح اواعيك، قلت له طب ما هيني شالح انا بالبوكسر قاعد هيك. قال لي لا اشلح اواعيك كلهم. قلت له كيف اشلح اواعية؟ غلط علي، قال لي اشلح يا حيوان، وعشق السلاح على اساس ايش؟ بده يطخ. المهم غوشوا علي وعلوا صوتهم علي واجبروني اني اشلح ايش؟ البوكسر. قمت عن الكرسي اللي كنت قاعد عليه وشلحت البوكسر.
دخلت اتحقق معاهم قبل ما يدخلوا التحقيق يكونوا ينضربوا ويتعلقوا ويعني يعمل فيهم اشياء فظيعه. هم عريانين مش هم لابسين. كان بس حطوه على ضوء اخضر ما ضوء احمر، طلع مش تقريبا نقول 20 متر زي هيك، وقف رجع قال لهم فكوني انا مش من حماس، طلع عندكم اخضر مش من حماس انا. ضل يغوص ويعمل، راح طخوه ورجع مكانه.
فكانوا يطخوا ناس كثير، كانوا عاملين زي الجوار هذا اللي حواليهم. يعني ليش الجوار مفخوره واحنا قاعدين في العريشه؟ بعد ما نقلنا ابنه وصار خلوا سبيله، قعدت انا نتفاجئ لو ما طخين واحد ولو طخوه قاعد في قلب الجوره، بس مين هو بنعرفهش، انا ما بعرفه.
كنا نيجي ندفن زي ما انت شايف حجم الجورة ولسه عميقة كمان أعمق من هيك. كنت أنزل أنا وزميل إلي، صرنا نوجه الرجال نحط راسهم هان ورجليهم هان، بعدين النساء على العكس نحط راسهم هان رجليهم هان، صرنا نحط فواصل بينهم لو حجر حاجة اللي قدرنا نحطه من هان بالسرقة طبعا. يعني ما كانش مسموح لنا هذا الشيء، كان هو بس بده اياك تدفن فوق بعض ترمي وتطلع.
بعد ما راح الطاقم الطبي رجع على المكان، راحت الدبابة مشت فوقها وراحت نفلتهم. بعدها الجرافة صارت تقلب في المكان، فطلعوا كل الشهداء اللي احنا دفناهم.
لما هم طلعوا الموتى لا ما قالوش يبعدوا، كنا نتفرج خلونا نتفرج. خلونا نطلع كيف بيفعصوا الميت فعص. كان العظمه لما تمشي تدبر تلاقي النفس تقريبا زي هيك، زي هيك تقريبا، نفس هيك لونه ابيض دايب.
طبعا القناص فاتح هنا بالحيطه هذه، حتشوفها انت هالقيت. وطبعا هان المقاسات تاعته هنا كانت اللي هي نقطه الجندي اللي كان قاعد هنا هذا مفترق الUNDP على 300 متر. هنا برج الشفا اللي هو موجود قبالنا هذا، ايوه موجود على 515. هنا مفترق اللي هو البرج الوحده، وهنا اللي هو 620. هنا مفترق حميد على 885 متر. هذول اللي هو رسمهم طبعا للقناص.
وانا طالع من باب المستشفى بدي اتجه على الطريق الامن زي ما قالوا لي، وانا راكز على الشاب اللي كان معايا، فاذ بالجرافه تبعت اليهود وهي جايه قدامنا، كان شاب مارد، طلعت فوقه فغصته وقتلته.
في يوم نادوا الجنود علينا، نادوا اسمي، حكوا انه بدهم ايانا، فطلعنا. كانت هاي الساحة كلياتها مقلوبة قلب، فاحنا بنمشي هنا واحنا ماشيين اللي هي زميلتي بتحكي لي احنا بنمشي على جثة. فلما طلعت الارض كان بني ادم ولسه الدم بيسيل منه، فكانت هنا في جثة واحنا ماشيين لسه يعني مبين انها جديد متوفية.
هذه اللقطات واللحظات الأولى بعد انسحاب قوات الاحتلال من مجمع الشفاء الطبي. هنا داخل الممرات والغرف في مستشفى الشفاء الطبي. لم يعد مستشفى ولم يعد شفاء.
لما رجعنا الصبح أول ما طلع النهار وأجت الإسعافات تبلش تنقل المرضى وتنقل الشهداء، في كل مكان حتى على باب المستشفى كان في شهداء، في كل مكان كانت الجثث. في المباني حكوا إنهم طلعوا جثث من المباني. على باب المستشفى كان في جثة على باب المستشفى نفسه. في الساحة كان كثير في جثث.
ما تبقى من جثامين الشهداء يبدو أنها جثة لطفل كان مريضا. جثامين المواطنين المسجلة في المنطقة منذ قرابة أسبوعين. هذا هو جثمان أحد المواطنين وما تبقى من وفاة أحد المواطنين.
هو
21 مجهول.
خالد جرادة.
21 مجهول.
محمد بشير جرادة.
12 من 30 مجهول 21.
كنت ادقق في الصورة ما شافش ابويا. كنا نفكر يعني انه كيف اقول لك الاقيه منظر احسن، منظر انه يعني منيح. الا بعدين الشرطي اللي قال لي او الامن اللي قال لي على ابويا، قال لي تعال وريك صورته. فتح مسك كم مرة قلب قال لي هي ابوك. اطلع الصورة مش صورة بني ادم، كانش هيك. ابويا يعني كان ناصح ويعني منظره حلو، بالصورة مرمي.
عمري في حياتي ما انساها ال 14 يوم هذول، من اصعب ايام عمري. انا 43 سنه فعليا، ال 14 يوم هذول عشتهم قول 140 سنه. صعب. حسبي الله ونعم الوكيل.
يعني كان إشي ما توقعناش إن إحنا نطلع عايشين، أو إنه إحنا يخلص الحصار نطلع عايشين من المكان، أو إنه يخلص أصلاً. فانصدمنا، حتى طلعوا هم وكانوا مولعين كل العمارات اللي حوالينا، فما توقعناش إن إحنا نطلع سليمين أصلاً من المكان، وانصدمنا لما طلعنا وشفنا المكان.
لو مرة بس تخفي بروحي المتعبة، لو مرة بس يرتاح لي بأرضك غفا، لو مرة بس ترتاحي من بطش العدا، لو مرة بس نفتاكي بأخلاق ممتلة. كنتي ولا زلتي أنا يا غزتي يا قمرتي، نالوا من ضلوعك وأنا كرث الحزن اللي بخاطري. يمكن إذا غالي الدمع ترخص لك الروح التي فاضت عذاب جرحك وطالب طول مليك المعتدي. يا دمعنا بعيني رفح يما الدمع لما نزح، طلت ضحى طلت شهيد حتى الفرح كرب وجرح. لما الحزن بالعشق يجوز كيف الحزن بغلى وطار. يا غزة أنا بروحي معاكي، ولو بلاك الدنيا جنة من وجع بحرك يا روح الروح. إن وجعنا إحنا نسقط إن سقطت ولن تسقط، لا ولن نسقط ما دمنا باقونا صبا كنهر الغيث. يا غزة أنا بروحي معاكي، ولو بلاك الدنيا جنة من وجع بحرك يا روح الروح. وجعنا إحنا
Would like to thank our colleagues from Al Jazeera 360 for this documentary that documented some of the crimes committed in a Shifa hospital. There are other crimes that have been carried out and committed in other hospitals, shelter houses, and so on. We'd like to talk now about international justice in the balance of the Israeli war on Gaza. Would like also to talk about immunity and impunity. So is the situation going to change after this war? We'd like to start now the discussion, and we'd like to give the floor now to Mrs. Professor Kathleen Powell from Cape Town. She is live with us via Zoom. The floor is yours, Professor. So South Africa has opened a legal pathway through a case that was presented before the ICJ. Everything is documented. And in your view, how important it is? In your view?
Thank you very much.
شكرا جزيلا.
I think there was a slight break in the transmission there, but I understand that what you want to hear from me is the extent to which the South African intervention to the ICJ, its applications to the ICJ, has helped to make the law more applicable to the Palestinian situation and to the dispute, the conflict between Israel and Palestine, in particularly Gaza. Of course, law has been playing a role in the Palestinian struggle since its inception. Many of the concepts of international law have been developed because of the situation in Palestine, or have been developed, if not created. Self-determination, the whole question of self-defense against non-state actors, the statehood of Palestine, has become a major legal question. So law has been the discourse all along, but it didn't seem to make a difference. Then you have the difference of some institutional involvement. Again, here we have had the General Assembly ask for an advisory opinion on the wall built illegally in Palestine. We have had Security Council resolutions and GA resolutions on Palestine. But now what seems to be different is the involvement in a contentious case. So a case in which the ICJ can issue binding decisions on whether Israel is committing genocide or failing to prevent genocide in Gaza through its latest assault on Gaza. My job, I think, is to tell you what the ICJ case looks like, what it has done factually, and what it might be doing legally as well. We need to be aware that this is a special and unusual situation. The ICJ doesn't have jurisdiction over all states. It only has jurisdiction over states and situations where there's been consent given up front. And in this case, the consent comes from the Genocide Convention, to which both South Africa and Israel are parties. And one may ask why the case was not brought earlier. And that, I think, is because earlier, while there may well have been very legitimate claims against Israel on the basis of war crimes, crimes against IHL, its treatment of the Palestinian people, possibly its denial of the right of self-determination, we haven't had a situation that could fit under within the confines of the Genocide Convention. Now we have one where that claim can be made, and it has been made by South Africa, and as a result, the case could come to the ICJ. Note that the Genocide Convention commits its parties to not committing genocide, to preventing genocide as well, and to not assist in genocide. So the ruling will have consequences for Israel and Israel's allies. That's one of the first consequences I want to highlight. In purely practical terms, let's look at what the ICJ rulings can and have done. They've increased the exposure on the Israel-Palestine conflict. They've provided some ideas of what the legal situation might be, although not very much. I'll explain why in a minute. They have weakened Israel's bargaining position on the global stage, and they've weakened the bargaining position of some of Israel's allies. Think of the case that Nicaragua has brought against Germany. And they've allowed for pronouncement on the facts on the ground. And this is possibly one of the most important developments the case can offer, because so far, whenever there's a conflict between Palestine and Israel, we just get two completely opposing sets of claims as to what's actually going on. And depending on which news station you tune into, you're going to hear a different story. So what this case, the possibility that it opens up, is that we can have a court of justice pronouncing on what really happened. And in this regard, I think it's very important that we've had our first finding of fact when the ICJ held that the measures that Israel claims to be taking to protect the people that it's herding into safe zones around Rafah are insufficient. And that was addressed in some detail in Judge Nolte's concurring opinion. So Israel was actually asked to justify, to explain what it's doing, exactly what it's doing, to protect the people that it is ordering to move out of Rafah. And the court found that the measures taken were not enough. Now, we just need to understand that these are provisional measures. This is South Africa's request for the measures that the court must order while the court is still deciding the main case, while it is deciding whether Israel's committed genocide. So at this point, while we're looking at the provisional measures, we should be looking at questions of procedure. We should not be deciding the merits. That's what the court keeps emphasizing. So all it's looking at is whether there's a plausible right being asserted, which is the Palestinians' right not to be subjected to genocide, and whether that right is in serious and imminent danger, which the court has found that it is. And I think even though the court has stuck to fairly procedural questions, it's ended up making suggestions on what the substantive law looks like. I noticed in the most recent judgment that Judge Barak, the Israeli judge, accepted that genocide is, that self-defense is no defense against genocide. You can't claim we're using force in self-defense if we have to commit genocide to do it. So that is even now a position from the Israeli judge. I don't want to take up too much question time. I just want to say that I think the contribution that South Africa has made is to keep this matter prominently on the global stage while there is so much other conflict around the world. And I think that it has provided a catalyst for various actions, possibly the ICC, the prosecutor's announcement at the ICC that he's seeking arrest warrants was encouraged not just by South Africa's action, but perhaps all the traffic around the issue of Palestine and Gaza that South Africa's action has helped to evoke. Bear in mind that there have been several invasions of Gaza before by Israel, and my impression is that none of them have managed to keep up the constant international pressure and international attention that this current invasion is doing. And admittedly, none of them have been as devastating as the current one, as we've just seen from that video.
شكرا جزيلا لك سيدة كاثلين، وربما أنطلق من السؤال الذي تحدثت عنه والذي تنظر فيه محكمة العدل الدولية: هل ترتكب إسرائيل إبادة جماعية في غزة؟ وأسأل هنا السيد ريتشارد فولك، هو المقرر الأممي السابق لحقوق الإنسان في الأراضي الفلسطينية. سيد ريتشارد، هل الأمم المتحدة والهيئات الأممية القانونية والحقوقية كذلك لم تتوصل حتى الآن إلى إجابة بخصوص هل بالفعل إسرائيل ترتكب جريمة الإبادة الجماعية في غزة؟
Yes, that's an important question, and it follows naturally from what we just heard from Kathy Powell, which lucidly explicated the background of this ruling. The ICJ is a complicated procedural institution that follows very conservative practices in reaching final substantive conclusions. And so here it has not fully allowed the pleadings either of South Africa or of Israel in defense against the allegations. And therefore, it's not in a position to pronounce upon the merits of the contention that Israel is guilty of genocide. In one level, this makes law seem almost stupid in its way of proceeding, because ordinary people have no doubt about the genocidal character of what's been happening, and the uprisings of students and demonstrations around the world confirm that from an early stage, what Israel was doing in Gaza was morally and politically unambiguously an instance of genocide. But when you come to law, you don't get an authoritative assessment until a tribunal empowered to do such an inquiry pronounces its decision. And this is a real handicap in a way, because by the time the substantive decision is reached, the events that are subject to such massive human suffering have already probably been superseded by other political conditions. So in one sense, it makes the substantive finding that is the core of the legal argument about genocide almost irrelevant to responding to the present situation. What makes it relevant, and what Kathy has spoken about, is that the court can, in recognition of the delayed substantive outcome, reach procedural findings that have substantive implications. And that's what it's done through the so-called provisional measures, the most recent on May 24th. There have been 3 phases of provisional measures. The most recent is the most direct and explicitly instructs Israel not to engage in any kind of military operation within the city of Rafah, and criticizes it very much for the way it handled the evacuation orders of those that were sheltering in Gaza at the earlier instruction of Israel. It's a situation that only literature can, in a way, capture, a kind of Kafka-esque nightmare where the Palestinians are shuttled from one highly dangerous and traumatizing context in this very tiny area of the Gaza Strip to another precarious place. So what we have here, to respond to your question, is a clear, non-legal perception of genocide that is confirmed by the way in which the imagery has been portrayed over several month period of the daily atrocities, combined with the assertions of Israel's top leaders that have in effect adopted a genocidal language to explain and justify what they've done in response to the October 7th attack. So you have both the facts on the ground and the intentionality of treating those facts in a completely dehumanizing, genocidal manner. So you have this non-legal clarity being now filtered through the legal procedures that are available at the international level. And the most important of these legal procedures is the International Court of Justice. But it faces 2 issues. One I've mentioned, that of the cumbersome nature of the investigation and process, which is so prolonged as to take up to 5 years possibly. And the other problem is the problem of implementation. The ICJ has no power of enforcement, and it is up to the Security Council, or residually the General Assembly, to try to make the ICJ findings operational and have a behavioral impact. But the UN was designed to be weak in this regard, and the 5 most powerful countries in the world were given this unrestricted right of veto. And the US has been protecting and insulating Israel from the provisional findings of the ICJ, and Israel has complemented that with a defiant posture which combines lies about what it's trying to do and continuing with its military operations that are focused on civilian devastation and have resulted in these incredible casualty totals. Let me stop there and let Kathy be available for questions and discussion.
ونشكرك جزيل الشكر سيد ريتشارد فولك، المقرر الأممي السابق لحقوق الإنسان في الأراضي الفلسطينية، الذي تطرق إلى عدد من النقاط بخصوص المسار القانوني الذي فتحته دولة جنوب إفريقيا. وهنا أنتقل إلى السيد رامي عبدو، مدير المرصد الأوروبي المتوسط لحقوق الإنسان. أنقل لك ما تحدث عنها السيد ريتشارد فولك. تحدث عن أوامر المحكمة، محكمة العدل الدولية التي صدرت بالأمس، قال هي الأكثر مباشرة، أكثر وضوحا هذه المرة، وإن كان إسرائيل لم تلتزم بالأوامر السابقة. إذا ما تحدثنا عن هذا المسار القانوني الذي فتحته جنوب إفريقيا، ما أهميته وإلى أين يمكن أن يصل بهذه القضية؟
شكرا جزيلا. أعتقد بالنسبة لي its consequences. Thank you. First of all, I think we should start by really saluting and commending the people of Gaza because of all their sufferings. And before we start about the impact of the South African case, and in answer to your question, I think it's important to look at the importance of South Africa approaching the ICJ, and this has different aspects we ought to look at before talking about the possible consequences. And the importance of South Africa being the country behind this case, the timing of this case, and also the perseverance and diligence South Africa has demonstrated in raising this case. I think, first of all, there is a strong symbolism that South Africa is the country behind this case, because, as we know, South Africa has suffered the kind of grievance which was the most apparent and manifested in the hearts and minds of people. And this on its own is a strong message that the oppressed people of the world are sympathizing with the Palestinian people against the racist, colonialist regimes, especially when the Palestinian people in the first 2 months felt let down. Now they know that there are other people who suffered like the Palestinian people and who are now showing empathy and solidarity with the Palestinian people. And this also gives importance to the Palestinian factions, the resistant factions. And the timing is important because the case started a month and a half after the genocide has started, and also this means a lot for the Palestinian people, especially when we know that there are many countries who did not want to name things by their proper names, and there were hundreds of exchanges and correspondence to adopt the term genocide, and many people, especially UN experts, who said so. And this has also caused some embarrassment for the civil society organizations and even the ICC, because in the past it rushed to deal with other cases, and in the case of Palestine it more or less ignored the situation for some time. Also, when it comes to international media, I remember one very well-known media outlet, when we presented to them and collaborated with them to document 4 cases in sound and vision, and they refused to take our case up until we presented documentation of the 5th crime of the Abu Sahlul family. Also the Al-Shifa hospital incident. I have relatives who were killed in that attack, and we have clearly documented that the Israeli occupation forces took a group of people and summarily executed them behind the building. And the timing of the South African case, I think this coincides with another case which the court is looking into, and that is the opinion asked, advisory opinion asked of the court on the legality of the occupation of Palestinian territories and the right to self-determination. These are not totally disconnected paths. They overlap in more than one way, and the case of the Israeli occupation is no longer just an occupation. It's a case of colonialism according to international law, and the legal team by South Africa presented a very powerful case. What caused us to be concerned is the absence of international organizations and the collapse of the civil society organizations and the targeting of every person who was moving, the disconnection of all contacts. So we used to receive reports on daily basis, so we wanted to give a comprehensive image, but we were surprised that the South African team has presented a comprehensive case, and of course their case was based on genocide, which is the biggest of all cases, and they gave a much wider scope from the point of view of time and place, and they also included the 76 years of Nakba and 56 years of occupation and military occupation and the 17 years of the blockade on Gaza. So the South African case went beyond the normal bounds of confining the Israeli occupation to the occupation which occurred in 1967 and took us back to the very departure point, which is the Nakba, the turning point in the suffering of the Palestinian people. And yesterday we saw the fruits of that when the ICJ issued new orders, and the continued approach, the South African approach of requesting more orders, created some sort of a legal monitoring of the case and took the Israelis to the most uncomfortable spot. And now Israel standing before an international court looking into a case of genocide. This is very unusual. Israel is not used to being held accountable. It's used to impunity, and this South African case has exposed the Israeli excesses in Gaza, and maybe Professor Falk and the first guest spoke about the ICC and the ICJ. The ICJ definitely tries countries, the ICC tries individuals, so therefore as a result of the South African case before the ICJ, this means that if a judgment is passed against Israel and Israel is condemned of genocide, this means this is a country, Israel as a country which perpetrated the crime of genocide. This will be, I'm worried about time. Your time is over. Thank you. We'll come back to Mr. Rami. Now we move to Lamis Addik. You are the head of the Palestinian Legal Authority, Ms. Lamis. What about the chances of litigation with Israel, and where will this process take us to? Thank you very much. I will be speaking in English. أعتقد أولا أننا
thanking everybody for having us. And I join you, and I believe we join you, not simply as guests, though I believe as Palestinians, we have become guests in every corner of the world. ضيوف بكل أنحاء العالم وبنفس الوقت إن شاء الله نكون شركاء. We envision ourselves as partners with all of you, partners for global peace, and partners for a future that is born from peace, security, and justice for all people. When we look at the encampments and the organizing and rallies across the world, it is not just in support or in charity for Palestine, but it is because the students and people globally understand both the threat that they themselves face, meaning our societies as a whole, and the potential for building a new future. I think UN Security General Guterres best stated it early on at the beginning of this genocide, that it seemed to him that international humanitarian law was time-warped, and that's true only in one sense. The entire truth is that the UN itself has specifically diverted and obstructed the very UN mandate to bring and keep peace and security by way of law, order, and decolonization. Paramount of those organs that obstructed the UN mandate, being the UN Security Council, under the domination of the US and Western governments. And it is through these institutions, initially, that Palestinians, who were once known to be the most hospitable people, became hostages in their own lands. The most peaceful and patient people turned or named as pariahs globally. And it is how those who pillaged and plundered Palestinians became globally and culturally normalized. It is through these mechanisms that the Zionist psychopathic sadism that you watch now in Gaza, but is not new to Palestine, because everything we see now was on a smaller scale for 76 years and on a bigger scale during the Nakba of 1948. And so our work proceeds from two axioms that we hope folks here will take away and try to remember and inform their work as we inform ours. First and foremost, the first shot fired in any war is the discursive. It is the law, both reproduces discourse, but also responds to discourse, which means that both discourse and law are mutable and responsive to each other. And number two, Palestinians have been the subject of a cruel and well-calculated project of psychosocial, political, cultural, and legal engineering. And one of the greatest achievements of this engineering was an unprecedented dehumanization of an epically victimized people, the Palestinian people. A racism so visceral that in the majority of the world, but certainly in the entirety of the West, our very names as Palestinians are not only controversial, but punishable. This dehumanization via this psychosocial and legal engineering has had also an unprecedented effect. First and foremost, the fragmentation of the Palestinian national body, the otherizing of Palestinians between good and bad, Palestinians inside, outside, and exiled, the fragmentation even of the solidarity movement in a way that mirrors our condition in Palestine, because in Palestine, we don't just have the Israeli occupation. We have three layers of colonization in Palestine: the administrative layer via the Palestinian Authority, and the layer of NGOs who are conditioned largely on these requirements of how does your funding work and where does it go, and does it go to the Palestinians that we've dehumanized or not. It has also created an incoherent and uncoordinated, contradictory, and sometimes schizophrenic political and legal movement that is both myopic and timid. It diverted Palestinian democracy to unelected and unengaged representatives who are not so much as allowed to coordinate and include not just Palestinians who are deemed to be the resistance, but including Palestinians who are not deemed to be the top Palestinians of concern since Oslo, the majority of us in the refugee camps and in exile. And the cementing of this was through the terrorist legislations. And these terrorism and sanctions law are exactly and primarily the way that we've come to the genocide in Palestine. It was initially when we discussed the question of how legal was it to bomb and invade a hospital, right, based on the question of whether there were terrorists. It was a question of our humanity because of the label of terrorism. And terrorism label, which is a framework that doesn't just occupy who gets arrested, but enters the realm of both regulatory, commercial, financial, who gets to live and die, and seems almost limitless in its ability to expand. It starts with the resistance, then it goes to the wives and the mothers and the children of the resistance until it reaches not just every Palestinian, but everybody who associates with Palestinians. In the US, as I speak, there are nations under the civil claim that these people are working or in coordination with terrorism. And it is from this basis, understanding how both coordinated and logical framework and demand. And we studied it. We began with the name, right? And we looked at what had happened. I know that we see a lot of big, sensational legal advertisements. We have sued and 100 lawyers here and 500 lawyers there. But as we began to dig in, what we found is that it capped the ceiling of the standard of work, legal and political work around Palestine. It capped the ceiling of expectations for success. And so we developed, though it had been in development, by the way, since 2018, both on the civil society and legal effort, we developed, and the name for us is critical, the PAL Commission on War Crimes, Justice, Reparations, and Return. And it is our intention that we are capped by nothing less than justice for every single grievance of every single Palestinian, present, historic, and well after liberation. Our initial work was to reactivate our defense mechanisms. We expected that there would be some massive response, and we were accurate. And so we lined up literally hundreds of lawyers to begin defending the first line of attack in the US, which was not just the workers and the immigrants, but really the first line of attack in the US by Zionists was the doctors and the lawyers. It was those in higher levels of power. Once we settled the defensive mechanism and also told these hundreds of lawyers, if you're coming in to work for Palestine, you too must speak with a consistent, clear voice on Palestine. You don't get to represent a Palestinian, then speak for what rights the rest of the Palestinian people are entitled to, and you don't get to demonize and otherize other Palestinians. Once that was settled, we proceeded with our offensive work. And our offensive work began long before the ICJ case was brought and before the provisional measures. And our goal was to issue actionable threats of legal liability, coming from a place of not human rights law, but what does it mean to face a real, meaningful threat of legal liability as we perfect our cases and our investigations. Our first public action was to file and serve a notice of demand on the members of Congress, letting them know you're facing liability, think twice. This had the effect of slowing down a vote. Our second public action was to serve those who were involved in the sales of Palestinian lands and settlements. And I don't mean just Palestinian lands in the 1967 territories, but well beyond, letting them know that they had liability, and their liability wasn't just in the human rights sector pursuant to the ICJ orders, but they had domestic, internal liability on licensing, on Ku Klux Klan's laws, on real estate licensing laws, and it was the first effort to actually shut down sales of settlements. The sponsors ran away and went underground. They erased themselves, right? And the buyers, the potential settlers, the people who would be going to live in our houses also disappeared. And it was just by service of this, and this had not been done previously. So our goal generally has been, as we're doing the work, to bring legal work to the standard that it deserves, to open up these investigations, and we still have very wide settlement investigations happening on the ground in Palestine in coordination with partners in Canada, Chile, and the United Kingdom. Our goal was to begin to expand the circumference of Zionist accountability and deterrence, right? By slowing down human, intellectual, and material resources, material being financial and military resources, by way of cases and compliance measures. And as we developed our own frameworks, we decided to use the very frameworks to which we have been subject, the ones that are very effective, right? The terrorism and sanctions framework, the corruptions framework, the racketeering frameworks, and not just looking at human rights law, but looking at the private sector, even going so far as we sent notices and demands for the war companies, but also pursuing, for example, products liability, regulatory and transactional and importation regulations as bases for our cases. We also engaged governments in the same way. We looked at governments and the global system really for its parts. Having done this for quite some time on issues related to other governments, we understood that governments aren't always moved by human rights. They have their own interests, their own obstacles, and their own needs. I'll wrap it up in 2 minutes. So we began the ICJ Pro Bono Legal Advisory Project, which did 2 things. We helped secure notices of intent from 4 governments, and we advise governments on how to leverage the provisional measures, both for domestic legislation. You don't need to sanction Israel if you can't, because we understand that there's fear, but you can implement micro-legislation on media, micro-legislation for no-fly lists, micro-legislation on what transactions look like.
سأعود إليه كلام جدا مهم عن تحركاتكم وما تقومون به على الصعيد الدولي. سنعود إليك في سياق الأسئلة. الآن نفتح المجال لإثراء هذا النقاش للسادة الحضور لطرح الأسئلة، لكن نبدأ بأسئلة متابعين على مواقع التواصل الاجتماعي التي يطرحها علينا الزميل محمد القاضي. تفضل.
شكرا وسيلة. هناك أسئلة كثيرة لكني سأجملها. جنوب أفريقيا، وهل ما زال الأمر متاح حتى الآن للانضمام لهذه الدعوة؟ وكذلك هناك أسئلة عن المذكرات التي تحدث عنها المدعي العام للمحكمة الدولية، وهل من الممكن فعلا اعتقال قادة الاحتلال التي هل من الممكن أن تثني المحكمة الدولية وتؤثر في قراراتها؟ والسؤال الأخير هو عن تضمين قيادة حماس ضمن المذكرة التي أشار إليها المدعي أو المذكرات التي أشار إليها المدعي العام، مع أنها
السيدة كاثلين باول التي ما تزال معنا.
Kathleen Power, who is still with us from Cape Town. If you wish to answer our questions, I hope you have heard our question. So there are questions about the possibility of Arab states joining the case that has been presented before the ICJ. Go ahead, ma'am.
I don't know why Arab states have not joined. I would love to hear the views of geopoliticists who follow Arab international relations. Any state party to the Genocide Convention can join this case. So unless they are not parties to the Genocide Convention, they are able to join. And I think it would be valuable if they did. I'm interested that there is relatively little buy-in from them. Is it possible for the occupation leaders to be arrested, was the second question. Yes, provided they end up in a country which is a signatory to the Rome Statute, so it's part of the ICC, because all of those countries, once there is an arrest warrant against the occupation leaders or anybody else, Putin is an example, the Russian president. Once there is an arrest warrant against them, any state party to the Rome Statute is under an obligation to arrest that person. There is a slight problem with sovereign immunity if you're arresting a head of state. I know in South Africa, domestic law says that that person must still be arrested. So what it means if the ICC does issue arrest warrants is that the travel of the people who are subject to the arrest warrants gets severely restricted. Can the ICJ be dissuaded by the USA and Israel and its allies? As a lawyer, I'd like to think not. I do think the ICJ has shown a fair amount of independence so far. Obviously, it's under political pressure as well. It knows that it will end up handing down orders that may not get put into effect, but they will have an effect in the long term if for no other reason than that they will add to the liability of Israel if Israel is finally found to have committed genocide in a legal judgment. And secondly, of course, these orders will have the effect of changing how allies of Israel can work. And I wanted to bring that up because there's been, some legitimate criticism that Israel is protected by the US. Notice that the US abstained from the last vote of the Security Council, which actually called for a ceasefire. That is a major change in position. And I think it is brought about in part by the pressure of the ICJ judgment so far and the other political pressure that has arisen. And notice also that it was the US that started building the flotilla to try and get aid into Gaza. So the ICJ judgments might avoid trying to make decisions that will show to be completely weak. At the same time, they are slowly moving further and further into trying to stop the offensive in Gaza, and I think that the orders are having an effect. By the way, one more thing, that offensive in Gaza, there's some disagreement on quite what the ICJ has ordered, but the judges themselves insist that what has been banned is military offensives by Israel that have the effect of threatening Palestinians with genocide. Barak, the Israeli judge, has taken this position, but is supported by others, that even now, Israel is not completely banned from using any force, even in Rafah. And of course, the order doesn't go beyond Rafah. So the ICJ still has some distance.
طيب هنا الفكرة واضحة سيدة كاتلين، مضطرة للمقاطعة لكي نشرك الجميع. سنعود بأسئلة أخرى. نتحول الآن لبروفيسور ريتشارد فولك ونتحدث عن الضغوطات السياسية على محكمتي العدل والجنايات الجنائية الدولية. إلى أي مدى يؤثر هذا النوع من الضغوطات على هذا المسار القانوني؟
That's very important, and I think it has already impacted it to a great extent. And we haven't discussed one avenue in civil society around the world by legitimating the political validation to global solidarity initiatives. And in my view, if the situation is to the kinds of concerns that our Palestinian participant just elaborated, it will possibly flow more from civil of the U.S. in particular. And just a small insight on the reason for some of the Arab governments.
يبدو أن لدينا الآن مشكلة في الترجمة، الصوت غير واضح من المصدر. على العموم أشكرك جزيل الشكر بروفيسور ريتشارد. أتحول الآن إلى المتحدثين هنا في القاعة. لا أدري إذا كان هناك نقطة محددة تريد الإجابة عليها من هذه
الإجابات واضحة. أنا إذا بدي أوضح شيء يتعلق بالقرارات أو الطلبات اللي أصدرها المدعي العام، بالتأكيد لدينا الكثير من التحفظات بخصوص الطلبات اللي قدمها المدعي. هناك كان ازدواجية للمعايير واضحة، هناك أنسنة للإسرائيلي على حساب الفلسطيني إذا قورن بالفلسطين، وهناك الكثير من القضايا التي يمكن أن نتحدث لها. لكن نحن نعتقد أنه صحيح أنه القرار أو حيثياته أو الطلب وحيثياته
details of the request has been written under some perhaps threat or fear, and the Palestinian side, for instance, the list included only 2 persons, Al-Daif and Sinwar, and there were attempts to add Abu Ubaidah. and then the name was withdrawn, and the American pressure led to add in the name of Ismail Haniya. We have to understand that the issuance of such kind of arrest warrants show that this puts an end to a long period of time of political immunity. So now we see these warrants that are being issued, and there is an approach that is being adopted, which is a case-by-case approach. And we remember Trump when he talked about sanctions to be imposed on a number of judges. We remember also the Biden administration, which condemned the fact that the Palestinian case was referred to the court, and prior to that, only half an hour before that condemnation, the United States of America hailed the warrant against one of the Ugandan leaders. So what are your moves and your efforts when it comes to international justice?
ICC warrants are not self-executing, as Professor Falk clarified. We look at the case of Rwanda. Most of the defendants have died, and we still haven't seen a trial or proper arrest of the defendants. Given these two things, you add the fact that in the UK, when there was a warrant for Tzipi Livni, the British government went in and changed the law. So really the power of this is in two measures, both the denormalization on a civil society level, but goes back to where I left off, which is this is the opportunity for governments across the world to undertake domestic legislation that can implement this vis-a-vis these individuals, and if not, then Zionist society as a whole. The second question that the brother asked regarding the impact on the resistance and the warrants against Hamas, we do believe that these are in fact problematic. Nonetheless, a part of our work is dedicated to seizing the discursive moment, the movement across campuses, especially in the United States, where 50% of the youth actually support Hamas, and we're issuing both legal briefings. We were just at the Carter Center, where we also made the proposal, which was adopted, to reject and condemn the designation of Hamas and the majority of Palestinian political parties as terrorists. And we believe that this is the ripest time to do so, because as we explained earlier, it is these frameworks that led to the genocide. As regards the reluctance of the Arab governments, we met with quite a few Arab governments in trying to get their participation or just to file a notice with the ICJ. And if you look at the case of Nicaragua, there's a case of Nicaragua versus Germany, not the strongest case, but inshallah it'll be developed. But Nicaragua faced sanctions afterwards. And what I got from these Arab governments was, oh, we can't go to the ICJ, but we'd sign on to a state-sponsored ICC filing because it's not state versus state. But even then, we're looking at fear for retaliation by the West, especially by the US, is my understanding.
شكراً جزيلاً لك لميس الديك المحامية والناشطة الفلسطينية. أشكر كذلك رامي عبدو مدير المرصد الأورو متوسطي لحقوق الإنسان. الشكر موصول لريتشارد فولك المقرر الأممي السابق لحقوق الإنسان في الأراضي الفلسطينية، كان معنا عبر تقنية الزوم. الشكر لكاثلين باول أستاذ المشارك في القانون العام جامعة كيب تاون. في الحقيقة تمنيت أن يكون الوقت كافي.
From the Euro-Mediterranean Observatory, I wish we had enough time for more and more questions, so hopefully we'll have more opportunities in the coming session. So we're going to have the following session that is going to be moderated by Maryam Bilalia. Thank you very much for listening.